Realists say that judges work backwards. The judge will debate whether or not to give a certain sentence, for example, for a driver who ran over a person, whether it is assault with intent to kill or reckless driving. They would then find premises that support it, such as precedences, rules, principles, and statutes. There are a few influences on the judge's original conclusion. There are prejudices, personal biases, sympathy or lack of towards witnesses, lawyers, and parties, the testimony of witnesses which may be biased by personal characteristics such as fallacies, as well as fact skepticism. This all affects the judge's credibility and what is literally heard and remembered. The second concept of legal realism is that law is and should be used to serve social needs. Professor Susan DeMock at York University says that criminals either care about law or morals, but not both. And this is the separation of law and morals. As DeMock says, moral deals with the internal state of an individual's mind, what they intend to do. Law deals with external signs and actions, what they actually did. The third concept is that law should be treated scientifically. This ties into Oliver Wendell Holmes' prediction theory of law, which says that law should be defined as a prediction of how the courts behave. Law can be best understood by focusing on what judges actually do in deciding cases, rather than on what they say they are doing. Lawrence Claus, professor at the University of San Diego, says that laws are words, but how do we determine which words are laws? Words that make up laws are essentially predictions of people's attitudes and behavior. In 1932, Jerome forcefully denied that the realists are positives, who are exclusively devoted to whatever's now happening in the legal world. The realists, he said, were all eager to improve the judicial system, to make it more efficient, more responsive to social needs, more just, if you like that word. Legal realism is the opposite of natural law. Natural law is the legal theory of Aristotle, Cicero, and Aquinas. It is ancient and is based on Greek and Roman philosophy. Legal realism is pragmatic, with 20th century ideas. It is modern, critical, and almost nihilistic. Both Jerome and Karl Llewellyn, supporters of legal realism, also endorsed natural law. As Jerome says, "I do not understand how any decent man today can refuse to adopt, as the basis of modern civilization, the fundamental principles of natural law." Conventionalists say that judges only apply the law which others make. Judges are passive and bound by law that pre-exists their judgments. Changes to law made by judges are corrections rather than alterations, and only legislatures can make new law. Realists say that judges are not impartial. There is no law that pre-exists the judgments of judges. Judges make and change law, and statutes and other sources of law are not law until courts say they are law. The strength of legal realism is that it is already deeply rooted in practices. Law should not focus solely on law's ideals, but incorporate reality by revealing how law falls short of normative ideals. The weakness of realism is that realism emphasizes realism, which may undermine law's idealism. Judges use legal rules to guide their judgments and decisions, and not as data, as prediction theory says, to predict what they should do. It is criticized for separating law and morality. Most legal questions are already clear-cut and not indeterminate, as realists say. It also endorsed the views that gave philosophical support to fascist regimes during the Second World War.